Welcome back, America. I'm Hugh Hewitt. It's nearing 1 a.m. in Iran. It's 20 minutes after 5 in Washington, D.C. President Trump has reconvened the National Security Council. We know what they're talking about. They're talking about whether or not to use American force in the aid of our ally Israel in airstrikes. Earlier today, David Axelrod pointed out that there had not been a formal debate on this in the Senate and that he thought that was wrong. I pointed out that, in fact, in 2011, President Obama used airstrikes on Libya without any formal debate. It is within the president's constitutional authority to order airstrikes if he believes it's in the national interest. He does not need the permission of Congress. There is no requirement for a conversation with the Senate. There is no conversation that he brief the Gang of Eight, though I think he will. Joined now by Charles C.W. Cooke, senior writer for National Review. Charles, the National Security Council has reconvened. What do you think they're going to decide? What do you want them to decide, or actually President Trump decide?
Well, I'm 50-50 on this, and I think that is deliberate on the part of Trump. I don't know what he's going to do. I don't think he wants anyone to know what he's going to do. And that is probably a big part of this story and has been for the last week. He made it seem a week ago as if he was indifferent toward Israel's hitting Iran in the first place. And now we learn that he is all in. So the strategic ambiguity is a part of this. What do I want him to do? Well, I have a caveat here, which I know you will disagree with, Hugh, and that is that I think Congress should authorize this. But what I want the United States to do, if it is necessary and if Israel can't do it on its own, is destroy the Fordow plant so that Iran cannot create a nuclear weapon. I think at this point, it would be a disaster to leave it half done. The facts on the ground are just different than they were a week ago. I was in favor of it then, but you can't half do this. So I think if we are necessary to getting that done, I don't know if we are, I don't know enough about the military aspect, then we should help.
I want to explore with you the constitutional issue, Charles, because unlike most lawyers, you're not a lawyer, but you actually know what you're talking about on the Constitution. I don't think this is even a remotely close call. He's the commander in chief. It's an air asset. This is not a declaration of war. He's not seeking it. And every precedent, whether it's Obama ordering airstrikes in Libya or going back to Clinton ordering airstrikes in the Balkans, back to FDR, the War Powers Act has never been tested, but it's not constitutional. Surely you don't think the War Powers Act is constitutional, do you?
No, although my objection to it is also on the congressional side, in that it implies and has been taken to mean by presidents that they can do what they want as long as they tell Congress. I mean, you're right, and of course, saying that Obama did this and that, and Clinton did this and that. So did Harry Truman in Korea. But what Harry Truman did in Korea was a break with the norm. In the United States, in the early years with the Barbary Pirates, did have congressional authorization. Now, both Jefferson and Madison did not get a declaration of war. Madison wanted one, he didn't get it. But he did get an authorization for the use of force. Jefferson got 3 or 4. So I would like to see Congress add to the existing AUMFs Iran. If this country is a threat, which it is, then I think we should not be relying on the most flimsy connection, which would have to be, if you look at the documents, that because Iran helped harbor or aid those who carried out 9/11, they are tangentially covered under the AUMF. I just think it's really bad for our civic health. But this isn't an objection on the merits. And I agree with you that modern precedent, although I disagree with that precedent, is certainly on Trump's side. He wouldn't be doing anything the last few presidents haven't.
Okay, so we're in complete agreement. Let me ask you about your reaction to the Supreme Court decision today on the Tennessee bill prohibiting the use of puberty blockers and surgery on minors. The court ruled 6-3 that this is, surprise, a legislative matter and not one for the courts. I applaud them because there are no such things as trans rights in the Constitution. There's simply a legislature in Tennessee that gets to decide this. What do you think, Charles C.W. Cooke?
Well, I think it was the right decision, and I was impressed by the majority opinion. I also thought Clarence Thomas did a good job in his concurrence, and Amy Coney Barrett proved to those who've been, in quite a silly manner, I think, insisting that she's the second coming of David Souter, that she is not. The key point here, and the press completely missed it as usual, is not whether, in the opinion of the justices of the Supreme Court, this law ought to exist. It's not even whether the claims that are made by trans people are correct or virtuous or sinful or whatever. It is whether or not the 14th Amendment, as understood at the time of its ratification, obviates Tennessee's laws in this area. And of course it doesn't. There's no equal protection claim against Tennessee setting elementary medical regulations. And this wasn't the case that was made by the ACLU, but there's no substantive due process claim either, which was the other avenue they should have gone down. This is such a straightforward case. It's preposterous to suggest that the federal constitution outlaws states governing the medical procedures that can be performed on children. Come now.
Come now, indeed. And I want to explain to people that we all have the same rights under the Equal Protection Clause. That's absolutely true. But we are not in a suspect class. We are not given any particular rights to a group of people who identify as transitioning from one gender to the other. The state of Tennessee can go the other way as well, Charles, and California can go the other way as well. It's up to the states to do this. So I don't think it's completely neutral. Expand. I haven't read Justice Barrett's opinion yet. I just got through the Chiefs. What did she say that impressed you?
Well, what Justice Barrett said, which was not spelled out to her satisfaction in the majority opinion, was that irrespective of the question of what degree of scrutiny should be applied and whether or not this was an equal protection case, the trans plaintiffs in the case are not in a protected class and cannot be in a protected class logically. So her argument was that even if there were some tangential equal protection argument here, it wouldn't apply to this area of the law.
I'm so glad to hear she did that. And I'm also glad to hear you mildly rebuke the people who thought Amy Coney Barrett was the second coming of David Souter. She's a very careful justice. She's very smart. I think, I just test this out on you quickly, the reason they did not uphold the Oklahoma charter school for Catholics is that she was recused. She's going to write the opinion overturning Employment Division versus Smith. She's the expert on that. And someone decided we can wait another term or two until another case is teed up. Do you think I'm out of my mind, or is that plausible?
I think you're completely right. And I think it for a couple of reasons. First off, she is extremely careful in her jurisprudence, as you say. She is a proceduralist, and sometimes that irritates people on the right, because even if she thinks that had we got to the merits, the case would have been solved 6-3, she will not get there. That is a matter of judgment. She is a judge. But second, I think she was clever here in making sure that when Employment Division versus Smith is overturned, and when the First Amendment revolution that we've seen in the last 10 or 15 years comes, she won't be accused of having done something untoward.
Unbelievably spot on. Charles C.W. Cooke, follow him on Twitter at Charles C.W. Cooke. Listen to his podcast, which is, of course, carrying his name, and listen to him on The Editors, the National Review podcast. Come right back, America. I'm Hugh Hewitt.